Interesting workshop on ecocide and environmental law. And this is panel number 3. And this panel is called Ecocide and Environmental Justice in National and Regional Legal Frameworks. As an answer to the mass destruction of the natural world, with all the direct consequences in terms of huge environmental crises, such as climate change, loss of biodiversity, and the severe poisoning of soil, air, and water, we are witnessing the arising of laws at both national and regional level that aim to protect nature in a really effective way. In this panel, we will analyze how ecocide laws are being developed in different corners of the planet, searching for environmental justice and real protection of the life support systems, and also providing the shift from an anthropocentric look at the planet and nature to a biocentric, ecocentric starting point, trying to build this new paradigm to allow humans and the rest of living beings to thrive in this beautiful planet that is our common home. We will start with Daryl Robinson, who is in Canada. As a little presentation, introduction of Daryl. Daryl Robinson is a professor at Queen's University in the Faculty of Law in Canada. As a Canadian diplomat from 1997 to 2003, he helped to negotiate the statutes of the International Criminal Court and related instruments. He advised on international criminal law, human rights, and humanitarian law. He also worked at the International Criminal Court and directed an international human rights litigation clinic. He was involved in the UCLA Promise Institute for Human Rights working group on the definition of ecocide and has written and consulted on legislative efforts to establish such a crime. The name of his ponence is called An Ecocide Wave of National Legislation, Feasible, Fast, Effective. So very welcome, Daryl. You can start.
Thank you very much. Can you hear me okay right now?
Yes.
Oh, perfect. Yeah, so my topic is about an ecocide wave of national legislation just in general. A lot of focus in the ecocide movement has been on amending the Rome Statute of the International Criminal Court, and I want to talk about the benefits of just waves of national legislation. People also, I'm just giving the summary up front, by the way, of what I'm going to say. People also tend to think about a treaty. Let's have an ecocide treaty, and I'm going to argue that's not even necessary. We might do wonderfully just with some sort of declaration or model law. And this national bottom-up approach would be fast, feasible, and actually really effective because we're going to use the machinery and the expertise of so many states. Another reason why I like a national wave is it can be bigger than just ecocide. We can also deal with a lot of other lesser crime. I've been working on ecocide for about 3 years, starting with a Promise Institute working group that Kate McIntosh was working on. I've also been discussing ecocide with a lot of states and parliamentarians. You know, when I talk to government officials about ecocide, there's often this kind of polite, amused skepticism in their face that I think they think it's a pie in the sky kind of idea. It's the same look that officials gave when we talked about having an international criminal court someday or banning landmines, that initial skepticism. And so one point just up front is that a wave of ecocide legislation, it's not just feasible, I think it's already happening. It's happening really, really quickly. The normal pace of things in international relations is from the moment an idea gets traction, it takes about 10 to 15 years to actually happen. Whereas Ecocide, it's gained traction. It really took off about 3 years ago, and it's already moving at a remarkable speed. So we got legislation just in legislative movement in Italy, Mexico, Brazil, Scotland, Belgium, Netherlands, European Parliament. All that's really recent. So we have this remarkable momentum going on. So the wave is real and the wave is happening, but my main topic is what's the best ways to make ecocide a real crime? And as I mentioned, a lot of attention goes to amending the International Criminal Court statute. And there's a lot of benefits, I suppose, to that, which is the ICC is considered the centerpiece of justice. We want to make ecocide the fifth crime. If you had put it into the ICC statute, you have 124 states that are going to implement it, and you can get some high-profile prosecutions. But there's also reasons to hesitate about it. When I raise ecocide, even with progressive, like-minded scholars, I sometimes get this little raised eyebrow skepticism. And I find out they're skeptical not about the crime itself, but they're skeptical about adding it to the ICC statute. There's a bunch of reasons to have those hesitations. One, amending the ICC statute is difficult. Two is the ICC is overwhelmed with the cases already on its already in its docket, and it's struggling with them. Three, it's just one small institution, so how many ecocide cases could it even do? Four, at the moment, the ICC has no particular expertise on these matters. I mean, it could acquire it, but it's not starting with that expertise. And five, because the ICC, it's only supposed to deal with the very most serious crimes, so ecocide would be given a very narrow jurisdiction. An alternative way to do it, instead of a trickle down from the ICC, is a bottom-up approach, where we have a wave of national legislation first. Benefits of that are, for the previous ICC crimes, the crimes were already recognized as customary international law. By contrast, ecocide is admittedly novel. It's legislative, it's new, it's progressive development. We're not asserting it's custom yet. So if we at least had this bottom-up wave first, that could bolster the case, maybe for customary law status, but even if not customary law status, at least a sense of legitimacy, familiarity, acceptability, and states would have this sense that there's been some actual concrete experience with prosecuting it. So that's the benefit of bottom up. And then, of course, another approach is tandem. We do them both at the same time, which is probably the smartest and best approach. Even though I'm an enthusiast for the bottom-up wave, my goal is to get 8 states to make legislation, and then 16, and then 32, and then 64. That's what my goal is. But at the same time, we can still talk. The ICC Assembly of States Parties is the natural forum to discuss ecocide. It has experts on international criminal law from all kinds of regions. Discussing it at the ASP helps keep a spotlight and focus and momentum on it. And then I expect that we'll have our bottom-up wave, and then, of course, ecocide, I think, will get added to the ICC statute and become the 5th crime. So that's one of the options, is the ICC. When people think of alternatives to the ICC, the first one I hear people mention is, well, let's not do ICC amendment, let's do a separate treaty on ecocide. And what I want to suggest to you is that even an ecocide treaty, it's not necessarily necessary. Well, sorry, I don't think it's necessary, and it's certainly not fast. If you think about the Crimes Against Humanity Convention, that convention, it's based on a well-established crime with a bunch of absolutely common sense provisions, and even that one is taking more than a decade. It's been dragging along. It goes from the General Assembly to the International Law Commission, back and forth a couple times. The General Assembly is now discussing. That's over a decade for what I consider just an absolute common sense treaty with nothing very new in it. So even an ecocide treaty might be too slow. So there's lots of other options. One option is just what we're doing now, which is lots of national legislators acting on their own with either no coordination or a little bit of informal coordination. There's a challenge with that, though. I've been talking with legislators, and a problem with it is ecocide is quite hard to define. Defining it is not quite as simple as some commentators think. There's a lot of nuanced issues trying to make the crime work, and every possible solution has completely plausible criticisms. So from my own contacts, I know that legislators acting on their own, who are up front, the first movers, they're in a difficult situation because there's a lot of things to figure out that aren't resolved yet, especially if you want to apply it on an extraterritorial basis. It would be nice to have some comfort that you've got some kind of multilaterally accepted definition. So a soft option that I like is we don't need a treaty, but we could just have a model law. A model law would just be a declaration by states. They don't have to, it doesn't have to be all states, just a group of interested states. If a group of states got together and made a model law would simply be a declaration. It wouldn't have to be formally ratified. It could build on the panel definition, which I think is the best available definition yet, the best starting place. There's been some later criticisms and innovations, so a model law could consider all of that. The European Law Institute, for example, thought that it wasn't clear enough in terms of legality, and they had their own innovations. So a model law could take a look at all the different views out there, get some sort of a definition with a bit of imprimatur, a bit of approval from a bunch of states. That gives comfort to legislators, especially if they want to apply it extraterritorially. So I think a model law can resolve what we're in right now is a bit of a coordination problem. It could accelerate the ecocide wave. And I also want to say a benefit of this idea of a model law is it can be broader than just ecocide. Ecocide is deliberately narrow. Ecocide is supposed to be the worst of the worst of the worst of the violations, but there's all kinds of other stuff we want to cover too. So a model law on ecocide could also say, by the way, states, I want you to do all kinds of things to strengthen your environmental criminal law. You should also deal with environmental crimes that don't have the same impact level of ecocide, or that don't have the same fault of ecocide, for example, crimes of negligence and so on. There's also all kinds of related crimes like carbon fraud or environmental corruption. So the benefit of a model law is it can deal with all kinds of things. And I think that this would be fast, very, very fast compared to other options. It's feasible because it's already happening, and it's effective because it taps into the machinery, the enforcement machinery of all these states, and taps into their expertise. So those are my remarks. I guess I might add 30 seconds by saying one other thing. Here we're talking about ecocide, so we're focused on criminal law. I want to emphasize that criminal law is only one tiny sliver of what's needed to make this transition to a sustainable society. There's all kinds of technological, social, economic changes we have to make. Sometimes when I'm talking with people about ecocide, they want the crime of ecocide to cover everything, and they want it to mandate every necessary reform. But let's remember that criminal law is a very crude and blunt tool. It's only to deal with the most egregious things, and it has to be working with thousands of other reforms that have to be made. So we're going to use criminal law to strengthen the stigma of the most egregious wrongdoing, because so far environmental wrongdoing has been treated as a regulatory offense, not with the seriousness it deserves. But let's remember that criminal law is just a part of a bigger puzzle, and we have to be working with the rest of that puzzle. And that's it for me. Thank you very much.
Thank you very much, Daryl. It's been really great to listen to all your knowledge about what is in the global scenario, all the different choices that we have regards having a legislation on ecocide. now we are going to listen to Paulo Busé. Paulo Busé is a Brazilian international criminal, environmental, and human rights lawyer with over 20 years' experience advising and representing human rights and environmental organizations in Brazil, like Observatorio do Clima, Greenpeace, Global Witness, and others. Being a lead lawyer at Climate Council, is one of the experts at Ecocide Advice Center and co-head of the Environmental and Climate Crisis Practice Group at Global Diligence. In collaboration with other lawyers, he has spearheaded a number of cutting-edge legal actions to protect the environment in Brazilian courts and advise on national ecocide laws. Paulo Busé is going to talk about perspectives from national legislation in Brazil, and his presentation addressed the step-by-step of the development of a Brazilian ecocide law, from the drafting of the bill to the political strategy for approval at the National Congress. So, Paulo Busé, very welcome. And, we cannot hear you. Now we can hear you.
Oh, yeah?
Yeah.
Hello.
Yeah,
It's an honor to be here. Can you see my, myself and my screen, no?
No?
Not yet. Now, yes.
Now we can, yeah?
Can you see my presentation then?
Yes.
Okay. Good, great. So, I'm gonna be very quick in this. Well, I'm gonna guide you through the step-by-step of the process of development of the Brazilian ecocide law from the political strategy, because we had from the very beginning of it, and when I talk, I am representing, to be very clear about it, a large group of people from academics, lawyers, and also politicians here in Brazil. You know, the very first step is building up a group of people, a coalition of actors from civil society organizations to, as I said, academics, lawyers, and especially politicians. And we had, from the very beginning of it, to consider the technical side of the project of drafting a bill with all the specificities I'm gonna present to you now, but also we had to consider the chances we have to approve it in the National Congress. So it is a legal project, but it is also a political project here. So beginning with the ecocide bill, the bill proposing the creation of the crime of ecocide in Brazil was already submitted, has a number. It was submitted by political party PSOL as an amendment to the Brazilian Environmental Crimes Act. We have an Environmental Crimes Act already. It is currently approved by the Environmental and Sustainable Development Committee and heading for deliberation at the Constitutional and Justice Committee of the Deputies Chamber of the Brazilian National Congress now, which is a very good news because according to some, the most difficult step was this very first, the voting at the Environmental and Sustainable Development Committee. Some deem it as a kind of a miracle, you know, that we got it approved there because it is a committee controlled by oppositionists, mainly ruralists, as we call it in this committee. So it is a very good news that we got it approved in this commission. Here is the crime. We draw from the expert panel's wording, which I deem a very good kind of a piece of legislation. And we thought, our group, that we should be in total alignment with what was going on in the international arena. We had to align with what is being proposed for the Rome Statute. Because for many reasons, we have to be in alignment with the international arena. As I said, the environment doesn't have boundaries, so we have to think broader than our own country. So it was very important that we could align with the international movement. The main differences are not in the translation, of course. I mean, one of the challenges we had was translating the term wanton. And we could do that by picking up some crimes here in Brazil that also has a term very similar to wanton, which is temerário in Portuguese, and I think you understand quite well the word temerário in Spanish as well. That's how we translated wanton. It was purposely because we have some crimes, some other crimes, like a financial crime that uses temerário, so which is a reckless management of financial institutions, which is actually a very serious crime, which in Portuguese is herência temerária, no? So we used this temerário as the translation for wanton, which fit really well in our criminal law system here in Brazil. This is one of the examples of the work of adapting the international crime to the Brazilian system. And as you will see, we inserted two paragraphs here, paragraph 2 and paragraph 3, that were a kind of an innovation, and it relates specifically to our reality here in Brazil. Paragraph 2 says the crime of ecocide is directed at senior officials responsible for decisions leading to the promotion, planning, financing, agency, contracting, management, and execution of activities that fit into the hypotheses foreseen, above all the hypotheses. And 3, the crime of ecocide does not apply to indigenous and traditional populations who continue to live in that traditional way in their territories. So our main concerns was that this crime is directed to the people, individuals, of course, who takes the decisions in the political world, in the financial world, and in the corporate world, and should not be applied to the most vulnerable, because this is something that happens a lot in Brazil. Whenever a new criminal law is approved, it is normally directed to be applied against the most vulnerable. In the outskirts of the bigger cities, think about the poorest in the country, think about Black people, particularly targeted. And if you think about ecocide, a Brazilian could always imagine the same taking place. But as we think of ecocide, we think of the Amazon region. So we could easily think ecocide being applied against indigenous peoples who live in the very front line of where the environmental destruction is taking place. So that's why we took care of inserting these two clarifications at the end of the crime. In Brazil, we have a very, I don't know if you know that, a detailed environmental protection system, legal environmental protection system, filled with law, ordinations, rules and regulations, civil, administrative, and even an environmental crimes law with something like 25 crimes. Problem is that we need to strengthen this system because it's not being able to halt the environmental destruction which is taking place at a very high speed and intensity here. So we definitely came to the conclusion that we needed to strengthen what I call the most intrusive arm of the legal system, the criminal law, in order to present new tools to the prosecution and the police to fight the ongoing and growing destruction of our environment here. The environmental crimes law is, to begin with, very dependent on administrative sphere, terms, principles, acts, provisions, and regulations of the regulatory bodies, IBAMA, ICMBio, the most important ones, which is far from ideal from the criminal. We always need to avoid, an excessive openness and dependency on other branches of the system. That said, we need always to try to adapt the criminal law, the crime, to the entire system to avoid contradictions in interpretation. Also, this is more important. The definitions of the crimes are not encompassing enough, so there's nothing like an ecocide in terms of broadness, and the penalties are too low. This is the most important aspect, which means that at the end of the day, nobody goes to jail. Nobody is afraid of committing the more serious kinds of environmental destruction, simply because there is no crime to tackle the broader and more serious kinds of environmental destruction. So we need a stronger kind of crime against the environment, definitely. Here is just for you to have an idea, the original wording proposed by the expert panels, and we build our law on this on purpose, as I said. But adapting to our web of laws and principles, beginning with our constitution. I don't know if you know that, but the Brazilian constitution has a very strong article 225, which foresees the protection of the environment for present and future generations, and says it is an obligation for a public and private actors, so it has to be in alignment with our constitution. It is in alignment, as proposed in the bill, with our constitution to begin with, and also in alignment with all our other laws, like the forest code, all the civil rules and regulations designed to protect the environment. So now some of the challenges we had. One is regarding the regimental element. In our view, it requires the presence of intent, but it's here is a very specific kind of intent. Intent regarding the conduct and knowledge regarding the consequences. with knowledge that there is a substantial likelihood of damage. Under Brazilian criminal law, though, it is clearly equivalent to dolus eventualis, what we call dolo eventual, which according to our legal doctrine, and especially court precedents definitions, means to act with the knowledge that there is a substantial likelihood of damage, admitting, accepting, or tolerating it. This is the most important side of the dolus eventualis here in Brazil. The last wordings, admitting, accepting, or tolerating it. Meaning assuming the risk, but tolerating the possible result. Which means that the accusation should be able to produce evidence that the defendant not only assumed the risk knowing of the likelihood, the substantial likelihood of damage, but tolerated, subjectively tolerated the result. This is obviously very difficult to prove in an actual case. But as Dario put it, it is actually very difficult, let's be honest about it, to apply the ecocide crime to an actual case. This is a subject for another discussion, of course, but it's important to have in mind that this is not an easy crime, to operate. It is, in our opinion, very important that, you can interrupt me if I lose track of time, okay?
Well, in fact, yeah, you have to finish, Paulo, because, yeah.
Okay, no problem. I'm going to finish.
It's so interesting what you are telling us, because it is to see the application of the definition inside Brazil, and it's very interesting. But we are running out of time.
Okay, no problem. I'm going to finish now. The last and perhaps most important aspect of the Brazilian crime is that it should definitely be, and it generated a lot of discussion. Some of the academics defended that we should have a crime of material result, but the majority voted for this to be in alignment with the international crime, a crime of endangerment. And this is, in my opinion, the most important aspect of it, because we definitely cannot wait for the results to arise, We need to anticipate the application of the law in order to try to avoid the results. That's, in my opinion, the spirit of this type of law, avoiding the results which can prove to be irreversible. This was the main part of the discussion. So here, culpability is linked to the creation of a dangerous situation and not to a particular harmful result. The criminal offense is to perform acts with the knowledge of the substantial probability that they will cause severe and widespread or long-term harm to the environment, assuming the risk, again, admitting and tolerating the probable harmful results. That's it from me. Thank you very much.
Muito obrigada, Paulo. Congratulations for your success in this first step to get an ecocide law for Brazil. As you mentioned, Brazil is one of the countries of the world where it is so obvious the relationship between ecocide and violation of indigenous human rights. And that's something to have into account. So now we are going to listen to Roxanne Chaplin. We are going to change a little bit the schedule because Roxanne has to go for another meeting. So I don't know if you are connected, Roxanne.
Yes, I'm here. Can you
Okay.
hear me?
Yes, we can hear you, but we can, now we can also see you. Welcome, Roxanne. Roxanne Chaplin is a lawyer specialized in environmental law. She's working in the European Parliament since January 2021, 21st, and where she is following in Marie Toussaint's team the Committee on Legal Affairs and the Committee on the Environment. She works on many issues related to environmental law, such as environmental criminality, access to justice in environmental matters, environmental and climate due diligence, and the protection of environmental defenders. And well, just 2 weeks ago, we received the really good news that the European Directive on Environmental Crimes had recognized ecocide inside this directive, and Roxanne has been working on this in the Marie Toussaint's team, and she is going to explain this directive, the European Union Environmental Crime Directive. So it's going to be very interesting. And also to start with, congratulations, Roxanne. Congratulations to you, to all the team, Marie Toussaint, Philippine, and the rest of the team for such an amazing work that you've done. So go ahead, please.
Thanks a lot. Thanks a lot, Mayde. I hope you can hear me well because my connection was not great.
We can hear you perfectly, yep.
Okay, perfect. So many thanks also to the university and to Stop Ecocide Foundation for organizing this event, and also for giving me the opportunity to speak on behalf of Marie Toussaint. She is very busy at the moment, but I will try to do my best to represent her today. Yeah, I will come back, of course, on the deal reached last week. But I also wanted to come back today on the different steps that enable us to reach this great victory at the European Union. So first of all, I will talk about the fact that why do we need to recognize ecocide also at EU level. Then I will explain how this concept became part of the political debate in the parliament and then after in all the European institutions. And I will finish by analyzing the deal that we reached last week and the different steps of the negotiation. So first of all, why do we need the ecocide at EU level? Mainly because we currently face a paradox. On one side, environmental crimes are growing at international but also at European level. But the EU legislation is very low and lack ambition. And indeed, the directive, the text we worked on the 2 last years was adopted in 2008, but was not revised since then. And we are currently living in an unprecedented times of crisis that require never tried before solution, and we really think that the recognition of ecocide could be and should be a never tried solution before, also at EU level. And we shouldn't forget that the EU have a major impact on the discussion at national, but also regional and international level, because the EU represents 38% of the states at the International Criminal Court, and also because all the legislation that are approved at EU level have to be implemented then at national level. Then how did the concept of ecocide become part of the political debates? to the point of becoming one of the central issues of the revision of the Environmental Crime Directive. I can say that when Marie Toussaint was elected in 2019, the concept of ecocide was barely known in the European Parliament and in the European institution in general. Marie worked on this concept even before being elected because she created Notre Affaire à tous in France, also with Valérie Cabanès. And so she became, and she came in the parliament with the ambition to recognize this crime also at European level. And I think we managed to succeed a lot of improvement in 3-4 years, because at the beginning when she arrived in the parliament, we were trying to we organized a lot of workshops, a lot of conference with, for example, Philippe Sands, with Jojo Meta as well. We try to raise awareness around this issue to show how important for the EU this crime was, and why the EU has to recognize it. Then Marie created in 2019 the Ecocide Alliance, which is an alliance composed of members of the parliament and at European and also national level. Now this alliance gathers more than 30 members in 18 countries, and it's growing every month. And at the beginning, we faced a lot of deception and failure, because all the amendments that we tried to table and to negotiate failed, because we didn't find at the beginning good allies in other political groups. But thanks to our work to sensibilize and raise awareness, we managed to include in some report or in some resolution from the European Parliament a call for the international recognition of ecocide and also a recognition at EU level. And then in December 2021, the European Commission came with a proposal to revise the Environmental Crime Directive. And at this momentum, we really thought that it was the moment for the EU to really recognize ecocide in a legislative text, and not only in soft law or in resolution and reports. So the directive on environmental crime was presented by the Commission in December 2021, and after the Parliament on one side and the Council on the other side had to make their own proposal on the text. And in March 2023, there was a historic vote in the European Parliament, because we took a position unanimously for the recognition of ecocide in the text. And we worked together also with Stop Ecocide International, but also some experts, international experts and also European experts, to try to adapt the international definition drafted by the expert panel in June 2021 to adapt it into the European context. Because as I think Paulo said earlier, there was some concept and some terms of the international definition that was also not really adapted to the European context, and notably the notion of wanton. So we managed to include in the text a new paragraph with a definition for. So we didn't manage to have ecocide in the operative part of the text, like the concept itself, because it's a very political term and very hard to have in the text just the term ecocide in the article. So in the Parliament position, we included a so-called offense of a particular gravity, defined as any conduct causing severe and widespread or long-term or irreversible damage to the environment. And this offense of a particular gravity was also defined in a recital, so in the first part of the text, with a clear reference to ecocide, so in a recital. So this was the position from the Parliament. But as the European negotiations are very long, after the Parliament took a position, we had to also convince member states, because in that position they didn't include anything on ecocide. So from April to November 2023, we negotiated, so the Parliament team with the member state and with the Commission, in order to find a compromise on many aspects regarding the text, but especially on this aspect. Also because the definition of offense of particular gravity, so the definition of ecocide, became the priority of the Parliament during the negotiation. And so it was a challenge to convince member states, because most of them were not convinced at all. They were saying, first of all, that the concept of ecocide was not sufficiently defined or too vague. They were also saying that they would prefer to engage in the international work and not to recognize it in EU legislation. But we could count on many supports. First of all, lawyers and experts, as I already said, and like Daryl mentioned, the European Law Institute, for example, that draw model law on ecocide. The support also from the civil society organizations and citizens. We indeed organize many protests, also with Patricia, that is here. And also we have a lot of petition online, supported by Remove and Ava. So all this mobilization also help, I think, to convince member states. And so what happened last week, because I think that was what you wanted me to focus more specifically. We agreed on the text, and I will try to be brief. I don't know how long was my presentation until now, but we managed to find a deal to include in the text, so in an article, a new offense called a qualified offense. And this qualified offense is defined with the same material conditions that were also set in the international panel definition. And I can read it now because the text is not available, is not published yet. But I can also copy paste it in the chat if you would like to later. So the conditions are a destruction of or widespread and substantial damage, which is either irreversible or long-lasting to an ecosystem, an habitat, or to the quality of air, soil, and water. So this definition aims to really target the gravest environmental offense. And we also mentioned in the text, and we refer to widespread pollution, industrial accident with severe effects to the environment, or large-scale forest fire, for example. And we also managed to include in the text corresponding higher sanctions applied both to natural and legal person when a qualified offense can be proved. It can be when the material condition of the qualified offense can be proved. And in the recital, we linked this qualified offense with the notion of ecocide, and we also included and made a clear reference to the ongoing discussion at national and international level. As I said, unfortunately, the text is not really ready yet, because the deal reached last week needs to be the text needs to be clear and also officially voted in the Parliament and by member states. It should be done by February or March, so it takes a lot of time again. but we really think that it's a great improvement, and it's not only a first step. It's really like a revolution at EU level. And when the text will be adopted, so like in March, when the member state and the parliament will vote in favor, then member state will have 2 years to implement it into the national law. And we really think that during these 2 years, member states will also have more pressure to take a position at international level, so to recognize it in the statute, the Rome statutes. And I wanted also to talk about the work that is ongoing in the Council of Europe on the Convention on the Protection of the Environment through Criminal Law. And I think that we'll use the work that we've done at the EU level to also include it in the convention. So what we achieved last week will also be maybe used at regional levels, at the Council of Europe level. And I think it's a very important text also in the current political context in Europe. As you know, many affairs related to environment are being destroyed by the right and far right movement that is ongoing in Europe. And I think that what we achieved last week is really important to show that we still need important legislation and legal tool in order to prevent and to dissuade any environmental crimes in Europe, but also in all the world. So yeah, I think I can finish on this. Of course, I will be happy to answer to any question, but I have to leave in like 10 minutes. So maybe you can also send me the question, and I can copy paste just now the definition in the chat if it can be useful. Thanks a lot.
Merci beaucoup, Roxanne. You said many interesting things. To start with, very often it happens that when we have a success in getting a law, we are, in general, we are not aware of the energy and the effort and the so many hours that a little group of people have employed in getting this achievement, this legal achievement. On the other hand, you have also mentioned something very important, that is the importance of putting together the work at political level, at legal level, at political level, but also having this with the support of the citizenship. And all together we can move forward, that this is the way things should be done. All together we move forward in a positive way. And then, of course, there is no doubt that having included Ecocide inside this European directive has set a milestone in the campaign to make Ecocide an international crime, and because now Europe is like the example for the rest of countries and regions in the planet. So, because you have to leave, if there is any question now for Roxanne? No? Yeah, okay.
Hi, Roxanne. It's Jaime from Spain. I have a doubt because I didn't read the final text, and I'm not sure, but I think there is no provision regarding the illegal use of poison and this kind of massive method that for hunting. Is that true, or you know, when especially farmers or hunters use poison in the ground, in the wild, and it may cause very harmful damages to the biodiversity. And for instance, I will later talk about that, but it may cause huge damages to the biodiversity. So in the Spanish criminal code is punished, this practice. I remember I proposed an amendment for the left political party, but I don't know if it was finally included in the debate or in the final text.
So in the current text, there are 18 environmental offenses defined, and then, for example, the first one is really important. It's the pollution offense, which is quite broad and can, I think, your case can be covered by this pollution offense, because it's like a broad offense which is not referring to a particular directive. Then in the text there is, for example, the fact that to use restrictive chemicals, or what else? Like, there is a list of 18 environmental offenses. I can also copy paste in the chat. But we lost, for example, I also drafted an amendment to focus more specifically on GMOs, and to make it like a singular and specific environmental offense, but we couldn't include it in the text. So that there is, like, to answer your question, there is this general pollution offense, which I think can be quite broad interpreted, and also, like, you can. Well, we lost on GMOs and also, like, on illegal fishing, for example. So the list of 18 environmental offenses is not as broad as we wanted, but it was part of the compromise and the deal. But I think that's also what I forgot to mention, is that there was an important debate on concept of unlawful and how to define unlawful, because we wanted to broaden this concept in order to not limit it to authorization that can be given to someone that can do an offense, and we managed to include a good interpretation of the concept of unlawful, which is not on. It means that if you have an authorization, but your authorization is in breach of a substantial legal requirement, that you can also be prosecuted even if you had this authorization. So this is also, like, very good improvement of the current text. I hope I answered your question. I saw that there was also a question on the extraterritoriality in the chat. I don't know if you would like me to answer it.
Yeah, there is a question in the chat that says, how does the European Crime Directive deal with damage caused by European corporations outside the EU? For instance, in Brazil, is double materiality be required? And if it exists in the case of Brazil, where would prosecution ideally take place?
It was also another fight for us, especially on the competence of EU jurisdiction. We wanted to make it compulsory for member states to be able to prosecute when we can prove that the damage was done in the benefit of a legal person established in EU territory. So, for example, if, like, a company working for Total, which is based in France, made a damage in Brazil, then they could be prosecuted and by French authorities and by French jurisdiction. We didn't win on this, but it remains an option. So basically, there is an article on jurisdiction, and so EU jurisdiction have to be competent for damage when the offender is a EU national, or when the victim is a EU national, or when the damage occurred in a EU state. And member states have the possibility, but it's not compulsory, it's not an obligation. they have a possibility to expand their jurisdiction also when the damage was occurred outside EU territory, but on the benefit of a legal person established on their territory. And why it's only an option and it's not compulsory, it's because if, for example, Brazilian authorities want also to prosecute it, there is a principle of criminal law that says that you cannot prosecute the same person 2 times, basically. So that's why it has to stay only a possibility for EU, and we hope for EU member states, and we hope that they will use it when, for example, there is a lack of prosecution in outside EU in another country, but it's still not. And the condition of double materiality, I think you referred to the fact that the crime needs to exist in the EU and also in the other state where you want to prosecute. And I think this is still in the text, and this is more related to national criminal law. Because we couldn't go, it's only a directive, like we couldn't go very far in criminal law at EU level. And then I think we also have to see how it is implemented in all member states, especially in this regard, because the text leave a lot of margin of implementation for member states. I hope it was clear.
Thank you, Roxanne. Monse? Merci beaucoup. Now we are going to listen to Patricia Willock, who is on my left side hand. Patricia is a founder and director of Stop Ecocide Belgium and coordinator of Stop Ecocide in French language. She is an award-winning photographer, born and raised in Democratic Republic of Congo. Her work has been exhibited in the Office of the United Nations High Commissioner for Human Rights, in UNESCO and in UNICEF, as well as the Belgian and Austrian federal parliaments, and featured in media such as Geo Magazine, National Geographic, UNICEF Book on 25 years on the United Nations Conventions on the Rights of the Child. She focuses her work on women and child development, social inclusion, community engagement, emergency preparedness, climate change adaptation, and ecocide. She's going to explain how a new ecocide law has been developed in Belgium, is in the process of being developed. And I would also like to say that Belgium is a country that for 3 times in a row at the Annual Assembly of State Parts of the Statute of Rome of the ICC has asked for the amendment of the Rome Statute to include this new crime, the ecocide crime. The paper of Patricia is called Belgium and the Criminalization of Ecocide, a pioneering country for global environmental justice.
Thank you, Maite. Hi, everyone. I would like to start by thanking you for your online participation and for your in-person participation. And I'd like to thank the organizers for gathering such an impressive panelists. It's important to have all the layers of societies, including academia, participating in this process to stop the mass destruction of nature if we're to survive. As a campaigner, I find it remarkable to see how much time and effort civil society must dedicate around the globe to create laws that will ultimately contribute to the survival of our own species. I guess when you take a look at international law, you see that it's been designed by humans for humans and that it has no ecocentric visions. It is as if human has been extracted from nature and we're not part of it. And unfortunately, this vision of law has led humanity to behave like predators towards nature.
We have to stop for a little because we thought that the presentation was included. You were watching the presentation, but you were not. Okay. This is mine.
La otra.
Esta no es.
Es esta. Al lado, creo. Es esta. Sí.
Now?
Sí.
Yeah? Can you see it now? Fantastic. Okay.
So, this division of law has led humanity to behave like predators toward nature, to the point where we have all lost our primal survival instinct, because without nature we don't exist. It is urgent to create an important shift of consciousness if we're to survive, and I believe criminal law can help us create this shift, and that the recognition of ecocide as a fifth crime will bring a more ecocentric approach to international law. So today I will talk about the case of Belgium and the recognition of ecocide. We started a campaign in Belgium in June 2021, the day the independent expert panel published the legal definition of ecocide. And since then, Belgium has led the conversation on the diplomatic stage, raised 3 times in a row the question of the criminalization of ecocide before the Assembly of State Parties in the International Criminal Court, like Maite just said, and is about to include ecocide into domestic legislation through the revision of the Penal Code. Under the influence of Belgium, more and more countries, including the Netherlands, Italy, Spain, Scotland, Mexico, and Brazil, are now initiating the same process. So I will tell you a little bit about the history of the legislative process in Belgium. What is remarkable, again, in Belgium is that this initiative did not emerge from civil society, but it started in July 2020 when Samuel Kogolati, a federal MP for the Green Party, in consultation with Valérie Cabanès, introduced a bill to the federal parliament to recognize ecocide in domestic law and to amend the Rome Statute of the International Criminal Court. So, in October 2020, after the election, the elected parties of the new coalition approved an agreement to form a government in which ecocide was mentioned twice. And this is huge because it is thanks to this agreement that Belgium has been able to do what it's been doing for 4 years. So, first of all, it started with a resolution in the federal parliaments urging officially the government to include ecocide in the Belgian criminal law, to support international effort to amend the Rome Statute that started with Vanuatu and Samoa, and to create a coalition of countries willing to ask for the amendment of the Rome Statute. So after this resolution, what happened is that the Justice Minister decided to gather an expert panel commission to revise the criminal code and to see the criminal code and to see if ecocide could be included into this penal code. In May 2022, the National Expert Commission for the Revision came back and gave a positive feedback and advice to include ecocide as a crime into the penal code, and proposed a definition that was very similar to the consensus definition. So what happened next is that in November, there was a first reading by the government, who approved it, and then it went to the Council of States. So the Council of States its main duty is to provide an advice on federal and regional governments regarding the compatibility of texts with international and national norms. And it sent its opinion to the government, reducing the scope of the proposal and the strength of the definition. And I will explain a little bit later why they did it. In July 2023, the Council of Ministers finally approved the inclusion of ecocide into the revised penal code, and now it's up to the Parliament to approve it in the next few months. All the work that has been done was closely based on the consensus definition of the international panel, and I think it's definitely worth to mention. So the decision last week or 2 weeks ago by Europe has a huge impact in Belgium because of the way Belgium is set up. So the path to recognize ecocide as a crime in Belgium has been very challenging. And this is mainly due to the complex institutional mechanism. But the recent recognition of ecocide in the European Crime Directive will fill the gaps and reinforce national legislation. So in Belgium, we're in a country of 11 million inhabitants, and the power is divided by the federal government, 3 communities, Flemish, French, and German speaking, 3 regions, Flanders, Wallonia, and Brussels. And the communities are more in charge of language-linked issues, and the regions are in charge of territorial issues such as environment. But the tricky part is that there is no hierarchy in the system, which means that the federal parliament cannot overrule any of the regional decisions, and this often leads to disagreement or political paralysis. On the top of that, the competences are mixed between regional sometimes and federal. So it's a little bit complicated, and this is why it was quite challenging. So in their advice to the governments, what happens is that the Belgian Expert Commission for the Revision of Penal Code emphasized the international dimension of the crime of ecocide. But the council decided to take a different approach, and they based themselves on the federal configuration of the states, and it's resulted in some restriction of the definition and the scope, applying it specifically to the aspect covered by the federal government. But we know that in Belgium, the environment is mainly a regional responsibility. So it's meant, so before the EU decision, it meant that in practice, only disaster in the North Sea would have been covered, and Belgian perpetrators of ecocide abroad could be prosecuted under extraterritorial jurisdictions. But following the recent inclusion of ecocide in the European Crime Directive, the region now have 2 years to include ecocide into their own legislation, and now the scope of the law is much broader. This is why it was very important, because imagine for us as civil society, we would have had to lobby 3 regions plus the federal parliament. So it really helped us to save some time. Now that Belgium is about to position itself on domestic level, it means that it can now initiate diplomatic procedure together with a coalition of countries willing to ask for the amendment of the Statute of Rome. So Belgium's commitment to recognize ecocide on domestic and international front has sparked diplomatic discussion at many international events and summits. So the Belgian context is a practical example of how the implementation of the crime of ecocide in domestic, European and international law is closely linked, and that all those layers of law on different, on European and international level complement each other. I must also talk about the role of civil society, like Roxane pointed. In Belgium, civil society played an essential role in raising awareness, mobilizing public opinion, and pressuring government to keep its promises. So every letter that we sent to political institution was signed by a coalition of 26 organizations, amongst which Greenpeace Belgium, Rise for Climate, the European Foundation for the Rights of the Living, Canopea, and Grandparents for the Climate, who have been our main ally. We took all the decisions together. We gathered 43,000 plus signatures for a petition asking the government to have an ambitious ecocide law. We demonstrated many times, on many occasions on the street, and we spoke at different events. The fact that other members of civil society spread the message of Stop Ecocide has proven to be very effective to build this momentum, because A lot of organizations like Greenpeace would just take our narrative to speak to members of the government or to lobby, and this was really a victory for us. So in conclusion, I guess what we have to remember from the Belgium case is that Belgium is on the verge of recognizing ecocide as an international crime. It is huge. The whole legislative process has been based on the consensus definition published by the international experts. Despite the legal gaps on regional and regional level that were caused by the complex institutional mechanism and the division within the country, the inclusion of ecocide into the European Crime Directive came to rescue the regional, force the region to comply to EU standards. And the diplomatic influence of Belgium in pushing for the recognition of ecocide has also sparked a lot of conversation at international events. And finally, I think that the collaboration between government bodies, international organizations, and civil society demonstrates that the collective and coordinated effort combined with political will, of course this is very important, is essential if we want to live in the world that we know now. Thank you very much.
Thank you, Patricia. Here, once more, we have seen, in the case of Belgium, the importance of getting the agreement between the politicians pushing the law at the parliamentary level with the support of the government in this case, and then the important role that civil society and NGOs have in all this process, having a word to say in the environmental protection. Also, as you have mentioned, is very important the case of Belgium, because it also shows that when there is an advance at the legal level, such as the recognition of ecocide in the European directive, this affects also in the making of an ecocide law at the domestic level. And also important to say that now we have listened to Paulo Busset, who has talked about the creation of a new law of ecocide, a law of ecocide in Brazil, and then how the process is being in Belgium, and that shows that at domestic level there are differences between how the countries work in legislation, and and the difference between also at the political level. So all the singularities that have the different countries makes special the development of an ecocide law at domestic level. Okay, so now we are going to give the word to Jaime Doreste, and he is the last panelist. Jaime Doreste, he is Spanish, and he is an associate professor of environmental law at the Universidad Autónoma de Madrid, an environmental lawyer who has been working for 20 years in the legal defense of the environment, handling cases for a number of environmental organizations such as Ecologistas en Acción, that is the main national NGO of protection of nature, then Greenpeace, SEO, BirdLife, and neighborhood associations. And Jaime is specialized, of course, in domestic environmental law in Spain, so he is going to explain how we deal with environmental crimes under Spanish law.
Oh, I send you the...
Necesitamos que nos pongas la presentación de Jaime también.
11. La presentación de Javier. De Jaime.
Hola.
Dios mío, ¿qué he hecho?
This is the process to codify Ecocide.
Wow.
No es.
How infinitive looks.
Yeah.
¿Cuál es? ¿Cómo
The
se
last
llama?
one,
¿Cómo
Jaime.
se llama?
Jaime.
Esta,
Sí, la
esta,
presentación es esa.
the last one, ahí la de abajo.
La de abajo aquí.
Ah.
Está. And can you see it?
I think it was nicer to see the infinitive than the final presentation. But anyway, first of all, of course, thank you very much, Maite, and everyone in Stop Ecocide for your work, and of course for inviting me to this panel, thinking I have something interesting to say about that. And I would like to apologize because my English is not so good as it must have, but I will try. And of course, getting late into the hall, it doesn't help too. But I will try. I think in my absolutely disaster, I even sent a not definite presentation, so maybe some seats are in Spanish, so I will try to translate the more interesting
Jaime,
part.
me vas diciendo que pase, ¿vale?
Sí. I think it's very interesting to get the word before your intervention, because we can check the difference and the similitude between Belgium and Spanish, and of course Brazil process and legal system. Because similarities are very interesting, but especially the interesting difference between them. First of all, of course, the main law in the Spanish legal system is our constitution. It was approved in 1978 once this terrible phase in our history that was the dictatorship of Franco, where we approved a new constitution, and one of the articles in the chapters regarding the rights and of the citizens was the 45 one, that is the one who recognized the right of a healthy environment. It is, of course, as it was an article thinking about human rights, it's a very anthropocentric vision of the environmental, in the one who is included in our constitution, especially in paragraph 1, as you can say, that said that everyone has the right to enjoy an environmental suitable for the development of the person, as well as the duty to preserve it. The second paragraph is the one who talks about the obligation of the public authority to ensure the rational use of natural resources, the one that was as I would name it later as sustainability development and all the concepts that came before. But it's very interesting to check that the third paragraph that said that criminal and administrative sanctions will be provided to those who doesn't comply with the provision of the precedent paragraph, one of the regional use of natural resources. So, if in Spain we have a environmental criminal law, it's because it's an constitutional obligation, and it's not very common to find this constitutional obligation in the comparative law at international level. It's not in the presentation, but I think it's interesting to point the case of Spain regarding the competence in environmental and criminal law, just to confront with Belgium one. In Spain, criminal law is an exclusive competence of the central government, just to make it easy. But in the other side, in environmental issues, it's a shared competence in which national government has the competence to approve the basis law. That means the minimum denominator for the regional government that have the competence to develop this basis, and, very important, the enforcement of this legislation. So we don't have hierarchized system, but we can say that we have, as the state law is the basis. No? Comunidades autónomas, our regional figures, can go faster, go up from this minimum of environmental protection, but never have the competence to legislate to reduce this base of protection. Okay, to comply with the constitutional obligation to develop a criminal system to protect the environmental, in Spain we have a first step in 1987 when it was approved a revision of the 1956, if I don't remember, código, ¿no? Pero el Código Penal era el del 96, ¿no? El de Franco. Oh, okay, the dictatorship penal code, criminal code. But at last, in 1995, we approved the first democratic penalty code or criminal code in Spain that include 11 penalty offenses, environmental offense in the cases. If you remember, the paragraph 3 of Article 45 said that the legislator has the obligation to set criminal and administrative penalty to enforce the environmental protection. Taking into account that administrative law penalties are set on every environmental law we have. Biodiversity law, waste law, water law, etc., etc. But criminal law, we have only one, with an special law regarding contraband, but that include animal and flora contraband. But under this exception, there is only one criminal law, that is the Criminal Code of 1995, with these 11 offenses. So please. Thank you very much. This is our penalty code, the ley orgánica regarding the majority system that sets our constitution. And this is one of the sheets in Spanish, so really sorry. We have the two main blocks. The first one are regarding the offenses against natural resource and environmental, and regarding flora and fauna protection. And the second block, please, okay, regarding the fires. As you can imagine, in a Mediterranean country as Spain, Portugal, or Greece, fires, forestal fires, are a huge environmental problem. So we have a decision of the legislator. I'm not sure to be shared for myself. Forestry fires are not included in between the environmental offense, but have a very similar structure. I'm not going to talk about the 11 environmental offense, but I will point in 2 of them: the pollution offense and how it's similar. Yes, thank you. Very similar in some aspects to the ecocide, and biodiversity offense because are not so linked to the European legislation. Okay, pollution offense is included in the article 350.
3 to 5.
55. I'm nervous and it's even. I'm not going to translate the article, but I will take a minute to explain the 3 main elements of this offense. Dale un poquito para adelante. El siguiente. Aquí. Okay, again in Spanish, but I will translate. The pollution offense have 3 main elements: the factual one, the legal one, and the element of result. The factual fact means that there must be a human act that we can penalty, and it's very broad, a very huge number of activity that can be said as pollution. The penalty code talk about emission, discharge, pouring, radiation, etc., etc., etc. To apply the penalty code, of course, this act of pollution, this emission, this discharge, has to be illegal, has to be against the normative. Not only because the polluter has no permit, but even in case he has a permit, the emission is not according to the permit. And of course, the final resort element, that is the result one. It's not compulsory that the emission, this discharge, this pouring, radiation, etc., cause real environmental damage. It could be applied to potential damages. Okay, it's not only a result offense, but it can be a potential one, or as said our colleague from Brazil, endangering offense. But of course, as I first said, the environmental legislation has his own sanction. And of course, a water legislation provides sanctions and penalties and fines to one who make a discharge without comply with the terms of the permit. So what's the difference between administrative and criminal law? Of course, the gravity of the situation created. The gravity of the situation, not necessarily the damages, because there are sometimes situations where the damage can be contained, but could have been catastrophic. Of course, if it's a catastrophic damage, we are talking about a main penalties provided. And we talk situation very close to the ecocide as we are going to check them now. Dale la siguiente. Oops. It's a problem when we use different software. Bueno, claro que lo mandé en PDF. Bueno, anyway, I will send to you later in PDF, so you can check the 3 columns. The one of the left is the definition of ecocide. All of you perfectly know that. The second one is the one who Roxanne has just explained, perfectly about the qualifying offense, and in the Spanish criminal code, in the article 325 and 327, we have the hyper-aggravated pollution offense. Is that act of contamination that I will read, that may seriously damage the balance of natural system and has produced a risk of irreversible or catastrophic deterioration of the environment. As you can check, our hyper-aggravated offense is quite similar to the precedent one, and it has a provision of a very high penalty between 5 and 10 years of prison. So I think the future environmental crime directive will not create the obligation to modify at least this penalty in this offense in the Spanish criminal code. Dale al siguiente, a ver si ha quedado bien. Well, this is perfect. Two interesting things regarding the pollution offense is that can be committed not only by an individual, but for legal entities, especially companies, corporations, etc. This is a very new concept in the Spanish penalty legislation, because the possibility to to sanction with a criminal law a corporation was introduced in 2012, if I don't remember mal. First, there was the slogan of Societas Delinquere non potest in Latin. But it have not only in Spain, but in our comparative legal system, it was a overruling of this conception. The second interesting point is that not only the dolo, the voluntary damages, environmental damages, but the negligent violation of this environmental is prosecuted too. So we talk about intentional damages or the wanton damages, as permit the Article 331, and I think it's interesting, at least in my professional activity. ¿Vale?
Estamos yéndonos de tiempo.
Sí, no, pero termino ya. The offense regarding protection of flora and fauna. But the main interesting point in this presentation, dale para adelante, sigue, this one. Okay. How to enforce the environmental law? We have two special systems. We have a special police force with competence on environmental legal control. The first one is SEPRONA, from the Guardia Civil, es el Servicio de la Protección de la Naturaleza. And in Spain, from 2005, we have a special environmental state public prosecutor, who is Don Antonio Bercher, Mr. Antonio Bercher, that is the one who is in the photograph. But the real enforcement body of the environmental law, not only in Spain, is the civil society. That we act not only in the street or making a policy lobby, but as in my case, bringing the law to the courts. And I think it's very important to remember that this paradox that you two talk about, Patricia and Roxanne, that civil society spend a lot of work and a lot of time fighting for get a good environmental legislation. we always get frustrated because of the result of this process. The law is not so good as it should have been. But, that's the paradox, we are the first to use this not as good as it could have been law to defend the environment. So we will meet in the on course of everyone said. And yeah, I'm finishing. All my work could be, no, espérate que te salta una. Es que está hecho para eso. It's just a point in the vehicle, in the white. But with the efforts of all of us, we can draw a nicer picture like this one. So thank you very much. I'm sorry for my English, for the time, for everyone. So for everything.
It was perfect. Thank you.
Thank you, Jaime. I think that all of us are very aware of the difficulties we all have when we have to develop an argument in a different language, a language that is not our mother tongue. I think here, of all the things that you said, there is something very, very important, that is this Article 45 in the Constitution, because this article, well, in Spain, there is a constitutional obligation to protect environments, and this is something to be accomplished by not only the public authorities, but also by the citizens. Mm-hmm. And that is really, really important, because that means the establishment of the duty of care of nature in our main legal body, that is the Constitution. And then, as you have shown, we have these regulations to protect nature in the administrative law and also the criminal law, but still the severe harm to nature is not there. Mm-hmm. So that's why there is a process of getting ecocide law inside the Spanish criminal law, penal code. So, well, let's see what happens with this. And we have to finish. There is no time for questions because we are out of time. And we are a little bit late, and we need to start the last panel. So thanks a lot to all the panelists. It's been a pleasure to listen to you. And, well, I think that you all deserve the last applause and recognition for all your work. Thank you.
Welcome to the fourth panel, the fourth and last panel to this wonderful day. It's called Environmental Crimes, Human Rights and Transitional Justice, in which we are going to explore the link between those topics. I hope the speakers delight us with their presentations on the relationship between human rights, transitional justice, and environmental crimes. Dear colleagues, each of you will have 10 minutes to make your presentation. After that, I will give you a subtle and friendly signal that you have 2 minutes more to round off and finish your presentation. So you will have 12 minutes in total. Let me introduce to Ana Elena Abello Jimenez. Ana, are you online? Well, Ana is not online. You are. Wonderful. So, Ana, welcome. Ana is a lawyer who has worked as a legal officer at the Chamber of Recognition of Truth, Responsibility and Determination of Facts and Conduct of the Special Jurisdiction for Peace for 5 years. She has also worked, among others, as a legal advisor of the Deputy General Prosecutor, as a prosecutor of the National Anti-Corruption Direction, as an legal officer at the Constitutional Court of Colombia. Ana Elena's presentation is titled Prosecuting Environmental Crimes at the Special Jurisdiction for Peace, the Experience of Macro Case 2. Ana, the floor is yours.
Thank you very much. Good afternoon for you in Europe. I'm very honored to share the panels with such important speakers, and happy to share my experience working at the Special Jurisdiction for Peace, particularly in prosecuting environmental crimes in macro case 2. Well, as some of you may know, the Special Jurisdiction for Peace is a transitional tribunal created by the peace agreement between the former guerrillas of FARC and the government of Colombia in 2016. The Chamber of Recognition of Truth, Responsibility, and Determination of Facts and Conducts investigates macro cases. There are currently 11 of those, and they have different methodologies. Some of them are national macro cases, focusing on investigating one conduct in national level, and some others are territorial situations that focus on several conducts that were committed in a particular territory. This allows to understand the territorial dynamics with a broader explanation of what happened. I've been working almost for 6 years now on case 2, which is a territorial situation in the cities of Tumaco, Ricaurte, and Barbacoas, investigating the gravest violations of international humanitarian law and human rights that occurred there from 1990 to December 2016, allegedly committed by the former guerrillas of FARC and military and state agents. I have to say that these territories are mainly inhabited by ethnic people who are indigenous people or Afro-Colombian people, and consequently, they have a vast extension of collective ethnic territories. These territories are located between the Pacific Ocean and the Western Mountain Range, which makes them very diverse biologically speaking. So for ethnic people, the territory is an essential part. In the words of the Awa indigenous people, the territory is who they are. So it's not only the land as such, but also all the relations that happen in it. So not only physical relations, but also spiritual. It is considered a living being with rights that has been affected during the armed conflict because of the loss of ecosystems, the loss of sources of subsistence, the impact on their sacred places, the loss of their food sovereignty and traditional medicine, among others, and all these impacts the way of living of the ethnic people and the possibility to survive physically, culturally, and spiritually. So in case 2, territory has been recognized as a victim. These ancestral territories I have been mentioning have been recognized as victims in the procedures. They are represented by the ethnic authorities of each ethnic people, and the way to coordinate with these authorities to participate in the procedure is by an interjurisdictional coordination. Therefore, the investigation of the destruction of nature in case 2 was approached from an ontological perspective that considers the rupture of socio-ecological relationships at multiple scales and temporalities, the degradation of life broadly understood, and the loss of the ability of communities to remain and flourish in their territory. In our case, in July 2023, this year, the Chamber issued a decision on the determination of facts and conducts allegedly committed by the members of guerrillas of FARC. The Chamber found 71 facts as part of a pattern of macrocriminality, of damages of nature and territory. 58 facts were about oil spilling due to the attacks against the Transandine oil pipeline, and 13 facts were about the contamination for criminal mining. Both of these patterns were found as part of the territorial policy of this armed group. So the investigation of macro case 2 was made, as I said, with an ethnic approach. And on this particular matter, it included the collection of evidence of environmental memory from an intercultural vision. So they gathered environmental engineers as well as intercultural experts from the ethnic people that lived in these territories, and they issued a report where you could find the facts that happened, the gravest facts, and identifying the victims, damages, possible perpetrators. They also describe their ecosystem from a cultural and spiritual description as well as biological, with georeferencing. And I mean, in the end, this made possible to understand all the ethnic vision in the environmental facts and damages that happen. Thanks to this report, it was possible to prove that the spilling of oil caused widespread long-term and severe damage to the nature. uh, for example, 50,000 barrels of oil were spilled, impacting at least 500 kilometers of rivers and 76,000 hectares of mangrove. And some experts have estimated that the damages would take more or less 15 years to recompose the ecosystems. So all this was a severe damage that, as I said, was proved thanks to this intercultural report. Also, I have to say that another pattern of macrocriminality that was found was the illicit use and damages of anti-personnel mines. So this was also considered as a contamination of the territory. One of the defendants stated in the procedure that between 2013 and 2015, the number of anti-personnel mines installed in these territories was approximately 5,000. And a lot of these mines are still there. So all of these were the facts regarding to environmental damage. Now, according to the applicable law, the special jurisdiction for peace has different sources. International law, for example, IHL, or international criminal law, international law of human rights, but also the Colombian Criminal Code and the Constitution. And it's important because the Constitution of Colombia recognizes that it is a country there is pluralism and it is a multicultural country. And the chamber interpreted in harmony all these sources and considered that the elements of the crimes were to be interpreted in these ethnic cases according to the own right of ethnic people as well. So the chamber took into account the vision of the ethnic people to understand and charge the crimes. So which crimes were charged in case 2? Regarding environmental damages. So the crime against humanity of extermination, because among the conditions of existence that were imposed to ethnic people that could have led to their destructions because of the restrictions on their food and their health ancestral systems, all this contamination affected that. The possibility for them to keep their traditional food with the crops and the access to water and that affected their health. The crime against humanity of persecution was also charged because, as I said, all these facts severely violated their fundamental rights, not only of the members as individuals, but also of the ethnic people as a collective. Also, and this is one of the important points of the advances or breakthroughs of the chamber, they decided to charge 2 war crimes related to environmental damages. One, the destruction of environment, and in this part, they faced a problem because the Rome Statute only have this war crime regarding international armed conflict, and the one in Colombia is non-international. So what the chamber asked was if it was possible to apply our own criminal code that includes a crime in the context of armed conflict, that prohibits the employment of methods and means of warfare intended to cause severe and long-term and widespread damage. So, yes, I can hear.
You have 2 minutes more.
Okay, I'll wrap up. So the chamber interpreted that it was possible to apply the Colombian Criminal Code, but following the case law of the appeal section of the Special Jurisdiction for Peace, whenever it's proved the severity of the damage. Also, they applied the Tadic test to find that there is a customary international law prohibition of the severe, long-term, and widespread damages. So it was possible indeed to charge this war crime, despite it was a non-international armed conflict. And last, it also was charged the destruction of cultural places. We do have that crime in our national code, but also the chamber decided to interpret the elements of the crime of the Rome Statute. When it says religious buildings, it should be understood that not only buildings in an occidental meaning, but also places in general, because ethnic people not always have buildings as cultural places. And also it includes not only religions, but the belief systems of these ethnic people could be also protected there. So in the end, I just want to say that it is very important to keep talking about this accountability, because ecocide in particular solves the problem of the impossibility or the difficulty to apply the war crime of severe, long-term and widespread damage to non-international armed conflict. It solves it, and even better, it doesn't require the link to an armed conflict, so it should be broader. And in the end, my only reflection would be to always remember that ethnic people have been the guardians of environment ancestrally, so it's essential to hear what they have to say when interpreting and understanding all these damages to the environment, and of course in charging these crimes as well. Thank you.
Thank you very much. And now is the turn of Esteban. Esteban Morel, are you here? Esteban?
Yes, I'm here.
Fantastic. Esteban Morel, Hungria, is a lecturer in criminology and criminal law at the Jaume I University in Spain. He has a PhD in law at the University of Alicante, Spain, and he holds an MA in criminal justice system from the University of Lleida and an BA in criminology from universities of Salamanca and Valladolid, Spain. He is also a member of European Society of Criminology and the Spanish Society of Criminology Research, where is the co-coordinator of the recent Green Criminology Group. He has appointed to the Spanish Committee of the International Union for Conservation of Nature, EUCN, as a representative of the World Commission on Environmental Law in 2023. Esteban's presentation is titled "The Need to Implement Restorative Mechanism in the Face of Legislate Environmental Harms from the Perspective of Ecological Justice." Esteban, please go ahead.
Thank you. Many thanks for organizers for inviting me. I apologize for not being able to attend in person, and I would like to present and share this presentation. Can you see okay everything? Because I can't see.
Yes.
Okay, perfect. I'm going to talk and present the results of our most recent research on localized human activities that have a serious impact on ecosystems. The research was published a few months ago, and it's part of a ERC Consolidator project called Ocean Crimes Narratives. First of all, I would like to explain the importance of a species essential to the planet, a plant called Posidonia oceanica. Posidonia is one of the most important plant species in the ecosystems of the Mediterranean Sea. This importance is mainly because it's an endemic species of this area due to its role in mitigating the effects of global warming, for example, and Posidonia meadows are markedly complex ecosystem in which microhabitats of great species diversity can be found. Posidonia are significant primary producers, allowing it to be a source of natural oxygen and therefore an important carbon dioxide sink. Likewise, other organoleptic characteristics of this species improve water quality. For example, the foliage of Posidonia allows the deposition of suspended particles as another example. And we must emphasize that the analysis present here is framing the field of ecocriminology. That is the perspective of the green criminology that studies ecological harm from an interdisciplinary approach using methodologies from other sciences such as ecology and taking as ethical legal foundation of the theory of ecological justice. Thus, it's necessary to carry out an integral analysis of the ecological harms. And for this, we must carry out a study of the impacts and consequences in the different levels of biological organization established in the affected ecosystems. In other words, it's a matter of analyzing the ecological harm generated by this activity through a system approach. The practice of desalination can generate an impact that, although authorized by the administration, may alter the aquatic ecosystems. This way, the object of a study of this work, in which, after explaining the procedure of the activity, we analyze the impact desalination of a specific ecosystem, the Posidonia meadows, in a territory specifically, no? Because it's an special interest for us because the Balearic Islands is one territory most vulnerable for the global warming, for example. No? We analyze how the consequences generated by this activity can be a challenge that ecocriminology must address mainly through the restorative justice. With this last aspect, we want to highlight that science has been indicating to restore the imbalance generated by desalination and thus be able to regenerate or repair the ecological harm produced. In a transversal manner, and previously mentioned, the discussion or analysis will be guided by those ethical legal postulates offered by the theory of ecological justice. Now I explain to the desalination process. It's a natural evaporation and an osmosis phenomenon, but the human intervention reverses this process, producing brine as a byproduct. Despite efforts to minimize environmental impact in Spain, there are no specific regulations and laws.
Esteban, can you hear me?
Yes.
Esteban, just a question, please. I'm sorry for the interruption. And we still seeing the same slide, and we are not sure if you want to move the slides, go ahead, or it's okay, the slides.
Okay, I'm approved now.
Now.
Yeah, this is the second slide. Okay.
Yes.
Just the suggestion is if you can amplify in presentation mode.
Yeah. Can you see? No?
Yes, we can see a beautiful pictures. Yes, wonderful.
Yes.
Please go ahead.
I'm explaining the introduction only. I'm explaining the introduction, how is the Posidonia oceanica and how is the desalination process. This is the first picture. all about it. I'm going to the desalinization process. Yes, that's perfect. It's the human intervention reverses this natural process, how I think. In Spain, there are not specific regulations regarding concentration of chemical components in the brain. Our project asks for the importance of addressing this legislative gap and notes that according to current Spanish law, desalinization projects must undergo an environmental impact assessment, even though there are not specific national or regional regulations. According to the current Spanish legislation, there is not national legislation or even regional regulations applicable to brine as a rejection. This is one of the most important problems in this process, because the brine, as a byproduct of desalinization, can have various impacts on aquatic ecosystems. Some of these impacts include salinity concentration. The brine released into the environment has a higher salt concentration than the surrounding water. The temperature, because the desalinization process often involves releasing water with the temperatures different from the natural environment. Abrupt temperature change can affect aquatic flora and fauna, and specifically to the Posidonia oceanica, because it's very sensitive to thermal gradations. The chemical impact, in addition to salt, the brine may contain other chemical use during the process. And these compounds can have toxic effects on aquatic organisms and Posidonia oceanica also. The other impact is the biodiversity effects, because the relaxed brine can have negative consequences for biodiversity in the surrounding area. Changing the sedimentation of the aquatic ecosystem, because released brine can affect sedimentation on the seafloor. In this turn, can impact benthic organisms such as Posidonia oceanica. The last impacts on marine life, because the release of brine can directly affect marine life, specifically in areas where seagrass meadows like Posidonia or other habitats are present. No? It's crucial to conduct a comprehensive environmental impact assessment and develop sustainable desalinization practice to minimize these effects on aquatic ecosystems. In this graph, we can see one of the most important effects as the desalinity increases. With concentrations above 38 PCU salt concentration units, a decreasing pattern is also observed in the mortality rate, which increased for the plant, as you can see in this graphic. And now we talk to the case study in Ibiza. Is the Talamanca Bay. The localization of this desalination plant is not insignificant. It's situated in highly tourist-oriented area, and the effects can be easily observed. In this one of the oldest plants in the Balearic Islands, it started operating in the 90s, and the outfall discharged the brine directly into the coast, how you can see in this picture, no? Directly affecting the species that live there, mainly Posidonia, but also the species that live in it as its priority habitat, I can say. No? And this problem caused great social controversy, with demonstrations in the media due to the changing water quality, and other administrations even asked to the regional government to take the necessary measures to mitigate the effects. No? We can see with the naked eye that these affect Posidonia meadows are shrinking, and these the three images we see that happening from 10 years ago. No? You can see in the first picture when the Posidonia decreased into the last picture that this is this year, and you can see that the discharge affect to the Posidonia meadow. No? And now we talk from a ecological restorative justice perspective. Some proposed are analysis below. No? In the first we have a dual focus to prevention and mitigation. No? We need to repair and restore the Posidonia meadows affect. No, this is the challenge for scientists and administrations alike. No, but the potential to restore has been demonstrated by the science itself. No, has scientific literature. The first of all, reforestation and restoration, the Posidonia affects. Restoring anthropogenically impacted species offer untapped potential to address global challenges like climate change. And settling transplantation is one of the best options compared to more traditional techniques such as adult rhizome regeneration. No? This is a well-known technique that has already been studied with positive results. And the other further developed these lines of research. No? In saline areas, has it also been found that there is a direct relationship between high salinities and the development of restoration. No? This is another example. No? And for the last picture, no, we have a discussion because it's an activity that is protected and authorized by relevant authorities, but which generates direct and indirectly impacts on the ecosystem itself and threatens the ecosystem service it provides. No? We could consider this activity illegal, but legitimate ecological damage to aquatic or marine ecosystem as is the Posidonia meadows, and improve environmental impact assessment, because these all take account to the scientific advance, for example, by including a comprehensive multi-level long-term studies. No? And we need to incorporate in this improved environmental impact assessment that three values, no, and another measures to reduce the impact. No? And criminology must continue in its analysis for ecological harms or ecological damage caused by anthropogenic activities within the broader framework of ecological justice. No? According to some authors, such as Lynch, Jessica Long, a global challenge has emerged that the human species is great. It is therefore necessary for our discipline to contribute to the study of ecological justice from the perspective of criminological research, no? Taking into account that our species is part of the ecosystem, affects, and above all. No? Thank you, and more, if you want more information about this project and others, you can consult my web. Thank you very much.
Thank you very much, Esteban. And now we will listen to Marina. And Marina Lostal is a senior lecturer at Essex Law School, United Kingdom, and a member of the International Union for Conservation of Nature, EUCN, World Commission on Environmental Law. Between 2017 and 2020, she served as a representation expert at the International Criminal Court. She has consulted for several organizations, including UNESCO and Geneva Call, and has experience conducting trainings on international humanitarian law to the military, peacekeepers, and armed non-state actors. She has developed the UNESCO guidelines for the protection of cultural property in armed conflicts, forthcoming, and is author of International Cultural Heritage Law in Armed Conflicts, Cambridge University Press. Marina's presentation is titled The One-Dimensionality of Human Rights Approach to the Protection of the Environment. Marina, the floor is yours.
Thank you very much for the presentation. I'm not going to talk about cultural property. I'm moving towards the protection of nature and the environment. I want to talk to you or take you into a bit of a philosophical journey, and I hope you will be with me by the end of the talk. Right, so in the last 3 to 5 years, there has been 2 types of developments when it comes to human rights responses, and I'm only talking about human rights responses to climate change and the environment. One has been dubbed as the greening of human rights, and is epitomized, for example, or is epitomized mainly by the recognition of a human right to a healthy, clean, and sustainable environment. a right that was adopted by the UN General Assembly about a year ago. The second trend, or the second development, is not yet a trend because it's more marginal, is the quasi-recognition of rights of nature by the Inter-American Court of Human Rights in 2020. Both movements, or both developments, the green of human rights and the recognition of rights of nature, are motivated by the Anthropocene and climate change. But even though they could be perceived as both potentially positive, their conceptual framing is starkly different. One, the legal strategy of the first, of the green of human rights, is merely to add a human right to the existing list that we already have of civil, political, cultural, economic, social, and so forth. And so the aspiration is to exist in the one world of human rights. The second one, the proclaiming rights of nature in the house of human rights, disrupts the foundation of its architecture and the axiomatic relationship that has existed so far between humans and rights, promising a deeper legal change or transformation. This morning, Montserrat, in her presentation, Montse, said, things are moving. And I'm here a bit to ask, but how far can they move? And the assessment that I'm going to give is a bit bleak, because I'm going to try to shine a light on the parameters of these two developments and expose the limits of how much they can achieve as far as they go so far. And to do that, I'm going to borrow and apply a philosophical framework developed by Herbert Marcuse, who was a German philosopher from the Frankfurt School, the School of Critical Theory, who wrote, published a book in 1964 called The One-Dimensional Man, one of, I think, his most influential work, which is a critique to organized capitalism, and back in the day also Marxism, but today is capitalism, and the consequences it has on the ability and willingness of us individuals to break through with the pre-established parameters. He describes organized capitalism as a system where the whole administrative apparatus works to perpetuate the achievement of its pre-established goals: efficacy, production of wealth, and consumption. His work, I've tried to simplify and take what is useful for its application to human rights, and I've taken three key ideas of Marcuse's One-Dimensional Man. The first key idea is the idea of assimilation. He speaks to the fact that individuals in advanced industrial societies self-identify their needs and individuality with the needs of the system. The aspirations of individuals match those of capitalism: production, consumption, and accumulation of wealth. Marcuse powerfully says, and this is in the 60s, people recognize themselves in their commodities and find their soul in their automobile or the hi-fi set. So today you can change that for the smartphone. The consequence is that we, or I'm not sure who we is, but that we have created an unparalleled affluence of consumer individuals. And we have lost the capacity to think critically because we live very well in this one-dimensional world. And this one-dimensional society is practically without opposition because we have, at least in the West, we have a lot, never done before. And this one-dimensional society or thought is replicated or reinforced systematically through mainstream politics and media. The second key idea of Marcuse is positive thinking. He says this assimilation of individuals into the system acquires a larger significance when the self-limitation of thought is also espoused by scientists, philosophers, and so forth. When the habit of thought practiced by intellectuals stays within the confines of this universe and becomes a description of affairs. Forgetting that the society that we live in, that the system where we live in, was once a new society, and it was a choice between different historical alternatives. And every day, this is a choice between historical alternatives. Positivist thinking, which is also happens in law, validates the concepts on which the system rests and accepts them critically. And the third key idea of Marcuse is the centrifugal force of the system, something that Niklas Luhmann developed, I think a bit later in his systems theory, and calls it the autopoiesis. That is, that systems reproduce and reinforce themselves through self-reference. Systems never try to extinguish themselves, but to establish themselves and, if anything, expand. So Marcuse says that this works because any ideas, aspirations, and objectives that by their content transcend the established discourse are either repelled by the system or reduced to the terms of this universe. So it's like if the system had two levels of safeguard. The first one is the assimilation. We normally think within the box. But if we think outside the box, don't worry, because the box will display all the forces to put you back in. That's again what Luhmann, although Luhmann was not, I think he was not ideological. He was not talking about capitalism, but about systems, whereas Marcuse speaks about capitalism and in the day also Marxism. What does this have to do with human rights and the environment? Okay. So I'm going to apply two of these premises to the human rights approach. First, positivism, the legal positive thought, which is a description of the status quo where Western thought is a given. And there is an environmental crisis that can be tackled because it is considered an isolable problem. It's a problem to tackle. So positivist thinking integrates the crisis into the problem. And the method of doing this is by adding a human right to the one that we already have, to a healthy, clean, and sustainable environment. Problems with this. First, it does not question the individualistic approach or nature that human rights has since its inception. Second, it does not interrogate, question, or problematize the centrality of humans as subject and the environment as object. And the environment only matters as far as it affects humans. The third is that the formulation of the right to a healthy, clean, and sustainable environment hides a Trojan horse, which is the concept of sustainability. Sustainability is a very charged word and is a site of hegemonic struggles. It presupposes aspiring to some sort of linear progress where the future is better, not necessarily greener, but better because we will have more. However, and by contrast, Andean indigenous communities do not share the view that we are in an underdeveloped state that needs constantly improvement. It also does not share the underlying belief of associating poverty with the lack of material goods or wealth with their abundance. Be it as it may, the concept of sustainability that has made it into the General Assembly definition of the human right to a healthy environment expressly mentions economic development as one of its pillars. And therefore, this reign of sustainability reinforces the idea that nature exists for human exploitation and economic growth. If I have 30 seconds, some months ago, the leader of an indigenous community told me that a very powerful US family linked, this is in the news, linked with copper mining, is planning to start a copper mine in the Amazon rainforest. And to the dismay of the indigenous community, of the local community, because this is going to bring devastation to biodiversity. But then digging into the news, I found that the Colombian president pictured this as a strategic step in transitioning to a greener energy and a gigantic opportunity for Colombia. So, political sense or not, this is the type of rationale and reasoning that the human right to a healthy, clean, and sustainable environment admits, because it's good in the longer term for economic growth. So this configuration of the human right to a healthy, clean, sustainable environment.
10 minutes.
Good.
You have 2 minutes more.
Good, enough. I like it to define it as a vampire that comes with its own wooden stake. And so that's for positivism. And the third key idea of Marcuse, that of autopoiesis, the centrifugal forces that bring you back, is epitomized by this decision of the Inter-American Court of Human Rights. Had nothing to do with climate change, but all of a sudden I was very excited the first time I saw it. In a contentious judgment, the Inter-American Court said that the right to a healthy environment also comprised, and I quote, an autonomous right that protects the components of the environment, such as forests, rivers, and seas, as legal interest in themselves, even in the absence of certainty or evidence of a risk to individuals. This means that nature must be protected not only because of its benefits or effects for humanity, but because of its importance for the other living organisms with which we share the planet. Very nice. But then digging deeper into the Inter-American Court of Human Rights system, the rules of procedure and evidence of this court take you back to reality and take you back to the box. Because for there to be a case before the San Jose court, there needs to be human harm. If there is no breach of a human right leading to human harm, there is no opportunity for locus standi, either by a human or organization. So in the end, as Luhmann puts it in the language of systems theory, the Human Rights Court self-corrects the judge's attempt to transcend current boundaries in a way that the court gives the appearance of referring to the environment outside itself, while only ever being able to refer to the system itself. This is a very bleak picture. How do we escape these limitations? Marcuse talks about negative thinking, about a bit switching the paradigm and starting to think differently, which is very difficult for those of us that are raised in this society. One sentence that I heard once and I thought was very powerful, I don't remember the authors, but it's not mine. It says, there is no such thing as a climate emergency. That's a lie. The emergency is capitalism. And how do we fight this? And there is a very evocative article by Alberto Acosta on the environment that says, and I'm going to say in Spanish because the article is in Spanish, solo imaginando otros mundos se cambiará este. Thank you.
Thank you very much. Thank you very much, Marina, for this wonderful presentation. Finally, as a finishing touch, we have Maite. Maite Monpo is the director of Stop Ecocide in Spanish language. Maite has a degree in law and is specialized in ecological ethics, sustainability, and environmental education. She is a writer, a seafarer, and a teacher, and has a long story working in human rights, peace, and environment, in direct collaboration with several international NGOs as a worker, volunteer, and activist. Maite has spent many years giving talks and lectures and developing environmental awareness projects. Maite's presentation is titled Relationship Between Rights and Nature and Ecocide, the Mar Menor case. Maite.
Thank you, Rodrigo. Well, I have the presentation, and I don't know if you can see it.
Yes.
I know. I think something must be done. Yeah.
Timing is not right. Time is not right.
No, no pongas todavía.
No, pues eso te digo. Time is not right. Ese. Que tengo los dos aquí.
¿Habéis cerrado la pestaña?
Esta es.
Sí,
pero
blanco.
Cerramos algunas, sí. Sorry. Para joderte la vida, ¿viste?
Pero muchas historias así que no.
La he fastidiado, ¿viste?
Sí, a lo mejor, a ver, un segundo, es que no veo.
que a lo mejor eso está en oculto.
Claro, pues,
invitado
sí.
está, ¿sabes?
Vale, es que no tengo el enlace de la... Un segundo.
De la conexión.
Sí, solo voy a decir. Perdón. ¿Puedes abrir la sesión de la... ¿Tú tienes el enlace de la sesión de la videoconferencia? Es que yo no lo tengo, ¿sabes? Sí,
Sí, veía.
Perdón.
Pues tenemos aquí porque tenemos muchos.
No está el historial.
¿Y si te lo doy en un pen? No tiene nada que ver.
no, es la sesión de la videoconferencia. Vale.
Adelante.
I think I can start while we are getting the presentation, because there is a little problem. I think I can start. Well, we are all witness of how mass damage and destruction of ecosystems, which now we recognize as ecocide, has been committed for decades with impunity and is taking place all over the world. This has led us to the current climate crisis, the collapse of biodiversity, and the increase in serious environmental harms. What is more, this is putting our future and that of millions of other living beings at risk, because it is affecting the very life support systems of the Earth. At the root of this severe harm to nature, we find that it is not illegal to cause it, as there is no specific law that criminalizes at international level the massive destruction of environment. So clearly, something has to be done regards creating new legislation in order to protect the Earth's ecosystems. Now we are. A ver, un momento que pare aquí. Che. Is it?
The presentation is not online, it's just in the room, but you can continue if you want.
However, this will be not enough. We, humans, must change our relationship with the natural world and turn from harm to harmony. We, humans, must establish the kind of relationship that many indigenous peoples have followed since ancient times, which is based in respect and care for our common home, the Earth. And this change of paradigm has started to happen as increasing numbers of people, communities, and companies are trying to build up a different relationship with the planet, basing their modus operandi on returning to a harmonic relationship in order to achieve a feasible and thriving future for all living beings. Historically, the radical changes in society have been accompanied by the law, and here it is more obvious than ever. Out of question is the fact that this change in the socio-economic paradigm needs to be supported by a criminal law that prevents the worst harms to environment and condemns those who are most responsible for them. And finally, a law that also protects the protectors of nature and ensures a livable planet for the generations to come. Oh, oui, almost. Well, in this global scenario, two new legal tools have emerged in order to protect the so precious ecosystems, granting legal rights to nature and the recognition of the crime of ecocide. Well, I continue?
Yeah.
Well, rights of nature and ecocide law are the two sides of the same coin. Both are two emerging and innovative legal pathways that aim for a systemic reframing of Western legal systems using an ecocentric ethic, reorientating environmental ethics away from the anthropocentric worldwide. For example, humans are perceived as central, separate, and dominant over nature, and catalyzing a transformation in how humanity relates to, values, and uses nature. For example, humankind as one of many interdependent species in the entire natural ecosystem. The main difference between rights of nature and ecocide law lies in how each framework achieves such a paradigm shift. And here we are. Yeah?
Yeah.
Okay, fantastic. So the first two, no. Okay, so all what I said, I was using only the two first slides, so you can continue. And then we can, the next one here. Okay. Rights of nature is broadly understood as an emerging legal framework that recognizes nature as a subject of rights with intrinsic value worthy of protection in itself, rather than a resource for human benefits. Rights of nature also introduces the intergenerational element of our present responsibility to steward nature in order to preserve it for present and future generations of all life. There are already a few examples of how specific ecosystems have been granted with legal status in different parts of the world and using different paths to achieve it. For instance, in Aotearoa, New Zealand, Te Urewera, a land formerly comprising a national park, was declared a legal entity in 2014, and the Whanganui River was declared a legal person in 1917. In both cases, the grant of legal personality is part of a process that seeks to acknowledge the colonial wrongs towards Hapu and Iwi, that is, indigenous descendant groups living and taking care of these ecosystems for centuries. In 2016, Atrato River in Colombia was granted legal rights of personhood by the Constitutional Court after years of degradation of the river basin from large-scale mining and illegal logging practices, which severely impacted the traditional ways of life for Afro-Colombians and indigenous peoples. More recently, McPee River in Quebec, Canada, has been granted legal rights in order to protect it from future threats such as hydro developments. It is also very important to mention that it is not only ecosystems which are recognized rights. The Earth as a whole entity has got them as well. In 2008, Ecuador was the first country in the world to enshrine the rights of nature in a constitutional document, affording nature the highest form of legal protection. Ecuador's constitution recognizes the rights of Pachamama, or Mother Earth, to exist and to maintain and regenerate its cycles, structure, functions, and evolutionary processes. And in 2010 and 2012, Bolivia passed national legislation recognizing different rights of nature, such as the right to life and to exist, the right to continue vital cycles and processes free from human alterations, the right to pure water and clean air, the right to balance, the right not to be polluted, and the right not to have cellular structure modified or genetically altered. La siguiente. Summing up to all what has been mentioned, criminal law is first meant to be a protective law, using a framework for punishment in order to avoid harm, in this case to nature. The mechanism for reorienting the values and ethics underlying our legal systems truly lies in the moral power that stems from the criminalization of harmful and irreversible harm to nature. The legal recognition of ecocide as a crime at the international level could go a long way to shifting attitudes and guiding behavior with regard to severe threats to the Earth's ecosystems. International recognition of ecocide will provide a much-needed framework to protect the most important ecosystems in the planet, forests, rivers, oceans, mountains, from the worst harms. It will ensure that all the regulations already in place are taken far more seriously at the highest level, driving better due diligence and stimulating strategic positive change in all the sectors of society related to these ecosystems. La siguiente. So here in Spain, we have now the case of El Mar Menor, the largest saltwater lagoon in Europe. El Mar Menor is the first ecosystem in Europe being granted with legal status, and it is an extraordinary case of citizenship in action to protect a loved and precious ecosystem. Over the years, protecting figures were established on this incredible ecosystem, some of them regional, others nationals, and even international. Ramsar Convention, a special protection area for birds, especially protected area of the Mediterranean interest in the Barcelona Convention. It is a regional park and a protected landscape. But despite all these regulations, El Mar Menor has been subject to continuous aggressions that have led an incredible lagoon to its near collapse. Among other impacts, we have... we have mining waste with presence of heavy metals, including radioactive elements, the dredging and widening of a channel in the 70s to build a private marina, chaotic human developments on its shores, conversion of traditional rain-fed agriculture to intensive irrigated agriculture, massive construction of desalination plants and illegal wells, and controlled discharges from macro farms. And as a result, none of the established protections, national or international, serve to halt the tragedy. It is like the chronicle of a death foretold by scientists and constant evidence of the massive pollution. Un momento. So, as administration does nothing to avoid tragedy, the locals started to mobilize and urge governments to react and protect. But years gone by and nothing is done. Demonstrations started to happen in the capital of the region, and also many activities are organized week by week at El Mar Menor beaches and villages. And then, 2 years later, everything started at university. Teresa Vicente, you can see her photograph here, holding a message of recognition of ecocide everywhere. a professor of philosophy of law at the University of Murcia. She was the promoter of the popular law initiative to grant rights to El Mar Menor. So there was an amazing mobilization for getting the 500,000 signatures on paper in pandemic times in 1 year. And it started in the region of Murcia, and it covers the whole country of Spain. And in this time, not only these 500,000 signatures were got, but 650,000 signatures. So please, never, never ever doubt in the power of people. In this, when the rights were granted to El Mar Menor, on 17th of September of 2022, the Spanish Parliament took the final step to approve the law that recognizes El Mar Menor and is basin as having legal rights. The law 19/2022 came into force in the 20th of September. And among other rights, you have the right to exist and evolve naturally, the right to protection, right to conservation, right to restoring. Now you can. So the law also sets a representation of governance with a committee of representative of administration and citizens, the monitoring commission with municipalities, and also there are representatives of business, trade unions, neighborhoods, fishing association, NGOs. And then there is the scientist committee, made up of independent scientists. So granting rights is an effective tool in the protection of high-value ecosystems, but more is needed, an international criminal law to protect the natural world from destruction. It is suffering in many parts of the world. As I've already said, granting rights to ecosystem and establishing laws to protect them are the two sides of the same coin. Thank you.
Thank you very much, Maite. Well, it has been extremely interesting how every speaker has referred to our topics: human rights, transitional justice, and environmental crimes. So, in honor to the time, we are in bad conditions right now. I just prepared some few words about your presentations, but I'm afraid we will have no time. Just allow me to say some words about sustainability regarding your presentation, Maria. I was in Glasgow in the COP 2026, and some of the speakers in every event, he said me, sustainability is a trump. It's a trump?
Mm-hmm. No,
it's trap. It's a trap. It's a trap. So because we can compare the situation. This is in my own words, but you say something similar in philosophical words. But he says something like, if you compare with your wife or your husband or whatever, your loved one, and I ask you how things is going in your relationship, and you say, well, it's sustainable. It's sustainable. This is the relation that we propose to have with our environment, with our nature. Mm-hmm. So it's not exigent. It's not exigent. So we need to be more exigent. And maybe it's not necessary to love the nature. I hope so, but it's not a requirement. But at least build a relationship with harmony and mutual respectful. This is the change of paradigm. I'm sorry, that's it. Thank you so much for everyone. We have no more time, and we move to our closing remarks.
Nos vamos, ¿no?
Sí.
Yes, thanks very much for those super fascinating afternoon panels. That's been really fantastic. So now we're moving to the last session, not the last session, the last segment of our workshop, closing remarks. First we got Nicholas Robinson, Executive President of ISIL, Chair of the WCL, Emeritus Professor of the University of Pace, who is joining us with a video recording. And immediately after that, we will turn to Karen Holm, Professor of Law, University of Essex, IUCN and WCL Chair on Environmental Security and Conflict Law. So first we go on with the video recording from Nicholas. I think we're good to go. Yes, okay, thank you.
It's a great privilege to be with you, to share some ideas and thoughts and engage your thinking with mine for the Green Rights Coalition. Green Rights Coalition has a very straightforward aim to secure a wonderful and supporting climate. It will change, it will not be the one we've had, but we can have, again, a stable kind of predictable climate. We have to have clean air, purged of the chemicals that polluted around the world. We have to have safe water, not just that we can drink potably, but safe for the fish, safe for all forms of life, and a volume that will be consistently available as the habitat for us humans as well as other species. And then finally, a sustainable food source. Humans have to have a secure and stable, nutritious form of food to grow and prosper, as do all other living creatures. So we have these as rights, if you will, as birthrights that are part of our organic development. They're not just amenities or privileges. And if we have such rights, then they have to be observed for everyone, for all. Ever since the first of the charters that tried to protect the rights of commoners, the Forest Charter of 1217 in England, it said the rights of the forest, the liberties of the forest are available to all, to omnes. Well, this right to the environment has been given a great recognition when the UN General Assembly on July 28th of 2022 adopted Resolution 76/300. 161 nations voted yes, zero voted no, and 8 abstained. There were some absent from the meeting. But basically, this was a tremendous endorsement for the fundamental norm that all rights, all human rights, are based on the right to the environment. Many nations, of course, have this right in their national constitutions and laws. Before the General Assembly acted, the state of New York, where the UN headquarters is located, had amended its state constitution to now have in its Bill of Rights, in Article 1, Section 19, the declaration that each person, anyone in New York, you don't have to be a citizen, each person in New York has the right to clean water, clean air, and a healthy environment. Well, these norms are tremendous and they need to be elaborated. They have to be teased out to understand the implications of these fundamental principles. There will be a number of corollaries that we can deduce from the right to the environment. Many have already been recognized even before the right to the environment was declared in the General Assembly. For instance, the human right to water. Now, we have other attempts to restate those corollaries. One of the earliest was the draft Covenant on Environment and Development, developed as a study paper by the IUCN's Commission on Environmental Law and the International Council of Environmental Law. It went through 5 editions and has been widely studied. A more recent global debate took place about the proposed Global Pact for the Environment, a tremendously creative and important initiative from France that spelled out in some detail, with consensus from jurists all over the world, quite a large number of rights that we can call, if you will now, corollaries to the fundamental human right to the environment. And the effort to clarify these corollaries is ongoing. Our colleague and friend, Professor Michel Prieur, and others have been proposing a further covenant, a human rights environment covenant, to go along with the 2 covenants on political and economic rights and social and cultural rights. So these corollaries are going to be developed further, and one of the great advantages of the Green Rights Coalition is we have a vehicle through which to carry on those debates and achieve consensus and persuade governments at all levels that these corollaries should be recognized as binding law. The duty of the state, if you will, especially in times of peril such as today, is to support the well-being of the environment, and that environment, all the people and plants and animals that depend upon it, is essential for life on Earth. Now, one of the key corollaries, if you will, is resilience. If we don't have resilience, we can't respond to climate change. We can't respond to the loss of a species and its ecological niche. We have to find a way to respond creatively and with safety. So resilience needs to be well elaborated. The Stockholm Resilience Center has done brilliant studies on some of the elaborations, but resilience is not yet a tool that needs to be observed in every act of national decision-making. There is such a tool into which resilience and all the other corollaries and rights can be read, and that is the procedure to study the impact on the environment of any governmental decision before it is taken. This is called environmental impact assessment. And since 1969, all nations and the international community have adopted legislation and treaties requiring the use of EIA. It is a standard tool. The International Court of Justice has determined that environmental impact assessment is a customary duty of states. A state must conduct EIA before taking an action that will have an impact on the environment of another state or the commons. And since most actions in this biosphere are closely interrelated, it's clear that we must undertake those studies. So we need to use environmental impact assessment as a tool through which to oblige governments in their studies to protect the environment and support the right to the environment in all the aspects that the Green Rights Coalition has been identifying. In the 19th and 20th centuries, and up until very recently, this concept of rights was segmented. So we had labor law rights, we had rights for workers, we had women's rights, we have the rights of the child, we have the rights of indigenous people. There are many rights that fall into these categories. But now, in the middle of our war on nature, a behavior pattern of the human species which is very destructive to the environment, we have to begin to integrate all of these rights. We can't treat them as segmented entitlements or privileges or rights of one sector of the world and our human society versus another. They're all part of the same cloth. They have to be treated together. And so the war on nature, which the United Nations has described quite capably in its study, the UN Environment Program study, Making Peace with Nature, which you can Google and find. Making peace with nature requires us to elaborate these rights and have means to enforce and implement them, such as environmental impact assessments. The integration of all these rights has to be intersectoral. It has to be across the sectors so that we find the rights, human rights in an old-fashioned version, civil rights, environmental justice rights for stopping discrimination against an economic or social or racial or ethnic group, the question of the rights of the UN concept of environmental rights, and then the rights of nature, which have been studied at the request of Bolivia and others to come up with, is there a framework for nature rights that has to be studied? But none of these can be treated anymore as segmented behavior. We must treat them as integrated reflections of the same core body of rights. For example, we have just decided internationally to sign last September of 2022 the Convention to Protect the Marine Environment in Areas Beyond National Jurisdiction, the Biodiversity Beyond National Jurisdiction for the high seas. This BB&J agreement will, in fact, now allow us to take proactive measures to protect marine phytoplankton. Marine phytoplankton are tiny little plants. No one has a desire to destroy them, but they are being impacted by pollution, by the movement of ships through them, by other economic activities that are damaging to their habitats. And so we must find ways to stop that. Why? Phytoplankton produce 30% of the oxygen that we have on this planet. Without marine phytoplankton, the rest of us who require oxygen in our life systems will be deprived of a fundamental part of our ability to survive. So phytoplankton is not a distant, disjointed little activity that some treaty has to worry about on the high seas. It is part of the rights of the environment of each of us. Without it, we don't have the concept of a healthful environment. So integrating these rights will require a new discipline. It will require a new analysis. You can use environmental impact assessment to do that because EIA requires you to look holistically at all relevant impacts and all relevant alternatives. So by defining them and building an ecosystemic approach into how we conduct EIA, we can use EIA as a tool to integrate the sectors of rights, the corollaries, and give as many as are relevant full application in any governmental decision that is about to be taken. So what will come of this? Well, I suspect we know a little bit already. The late Professor E.O. Wilson of Harvard University proposed that we should be setting aside about half the Earth to live as it is now. People can live there, animals can live there, plants can live there, but they should have no big economic development. We don't need roads and massive refiguring of the habitats. We must learn to live within the half of the Earth that helps sustain life, such as that part of the marine environment that gives us oxygen. We must learn to stabilize the ecosystems that exist. And in the course of trying to figure out how to have a secure climate, stabilizing ecosystems is going to be critical to stabilizing climate. So we're entering a new phase of humanity's consciousness and humanity's ability to use law and the environmental rule of law to advance the well-being of all of life. This is a daunting task. The mission of the Green Rights Coalition will not be easy, but it is a wonderful task for all of us to engage in and participate in and learn from each other and share our knowledge. If we do that, we can also help protect future generations and the planet itself. So I wish us all good success in these ventures and my full and active participation with all of you.
Thanks to Nicholas in New York for giving us that recording. And let's check if we got Karen online. Are you with us, Karen?
Can you hear me now? Sorry.
Yes, perfectly.
Oh, hang on. There's.
I think the picture is coming up. Yep, there you are.
Can
Very
you
good.
see?
Yeah, we can see and hear. Perfect.
Okay, I can't see me, but that's fine by me. So you happy for me to go? Sorry.
Yeah. Sorry, go on whenever you want. Good. Thanks for coming in.
Thank you, Thomas. I just wanted to say just a couple of remarks. I haven't been able to attend today. I have teaching and meeting commitments here at Essex. But just as somebody really interested in this topic, and I know a couple of my colleagues have been with you today, and I'm sure their presentations were amazing, Matthew and Marina. But as chair of the specialist group on environmental security and conflict law, as part of the WCEL of the IUCN, I just wanted to, well, first of all, thank Thomas, Monsi, and everybody in Madrid, the university. I'm sure you've done an amazing job, and I'm sure it's been a really rich, interesting discussion. I am so sorry I've had to miss it today. I've been in many meetings, and every minute I think I wanted to be there with you instead in Madrid, to be fair. But we were really happy that we could help co-sponsor the event. But all of the organisation has been done by Thomas and Monsi, so a huge thanks there, I'm sure, for everybody. But this is a really important issue: ecocide, environmental crimes, environmental justice. There's been, as you all know, there's been huge developments, key developments in the last few years, and this is an area that I'm sure will move in the next few years too. And it's an area that the specialist group has been working on, and we aim to work on in the next few years. So I just wanted to plug really the specialist group and ask if anybody isn't a member, if you want to join IUCN and either the WCL, which is the legal commission, or any of the other commissions, please just go to the IUCN website, where there's a big yellow button that says, I think, get involved or something like that. And then if you look at the commissions and look at the way to join, we're always looking for experts to be involved, to engage in discussions like this and to move things forward. So ecocide, just one more minute. Ecocide is one of our topics, our key topics. Another one is more to do with armed conflict and the International Law Commission principles on protection of the environment in relation to armed conflict, and we're trying to put some guidance or additional assistance, I think, in place for states. So if anybody's interested in those topics, please do either drop me a line or, as I say, join IUCN, and we'd love to see you in the SG. Thank you, Thomas, and thanks to everybody for what I'm sure was an amazing conference today.
Thanks so much, Karen, for joining in, and thanks again also for the support you've given for today's event. We really appreciate it, and we missed you here in Madrid, but good to see you. Good to see you online. So with that, folks, I think we're moving to what do we call it? We call it our concluding observations by the organizers. So that's Manse and Maite and Rodrigo. Right, okay. I think I will just open up by saying a few words and hand over to colleagues then. So, first of all, thanks a million to all our wonderful presenters and discussions today. It's been very enriching. We covered a very wide range of issues, even when we thought, when we put the workshop together, that it sounded, pretty confined. But I guess it just means there really is a lot to talk about when we talk prosecuting ecocide and finding more accountability for environmental crimes and the crime of ecocide in particular. So I don't think it's possible to do justice to all the topics and themes that we covered today. So maybe just very briefly that one thing for me anyways that came out of it is that we're seeing a lot of progress in terms of environmental crimes accountability, that things are moving at a certain level at the moment, both in national jurisdictions, and we talked about the European Union Environmental Crimes Directive, and we talked about the debate of seeing ecocide included as a crime at ICC level. And one thing that really comes to my mind is how fast-paced and how powerful the ecocide movement has been to achieve so much change in really a fairly short time when you think about it, and especially if you think about it in a comparative perspective, I suppose, with other things that we human rights and environmental lawyers have been, and activists have been fighting for over the last many decades, then really the pace with how we're moving here is impressive, even of course if there are many challenges ahead. So I'm not saying we're there, but good progress certainly is being made. So I think we can thank ecocide and environmental activists for a large part, at least for what's going on. And I think maybe with that I just want to repeat our gratefulness to the funders and supporters of the event. So thanks again so much to the International Council of Environmental Law for supporting our event. Thanks so much to the International Union for the Conservation of Nature and the World Commission on Environmental Law. And thanks also again to the Pax Natura research project led by Mons and Laura that we heard from earlier today. And thanks to the different university departments that have helped make today's event possible, especially perhaps the audiovisual team supporting us here today. Thanks very much for that to you and your colleague who was here earlier today. And again, of course, a huge thank you to Stop Ecocide and Maite and Rodrigo. It's been a great journey getting here today. So I'm sure we will collaborate in the future again and something similar, something different, who knows. So a warm thanks from us at the university to you and your organization. Okay. Thank you everyone. On to you.
Thank you. I have to subscribe all your words. I think that one of the most important aims of today's workshop was to explore avenues for getting a greater accountability for ecocide, and I truly believe that we have accomplished this goal, and we have food for thought to continue debating and working for the months ahead. There will be new developments because things are moving, and it is clear that prosecution of ecocide is key at the same time for avoiding impunity and for justice and for a sustainable peace. So thank you very much to all of you, to Thomas, to the co-organizers, Maite, Rodrigo, the Dean, the Vice Rectorate, the partners, ISEL, WCL, Professor Karen Hulme, Professor Christina Boyd, Professor Robinson, all the speakers, the audience, thank you. Thank you very much. We are very, very grateful, and to be continued.
Yeah. Well, thank you, really thank you to the University, Carlos III, and to Thomas, that was the starter of the idea, and to Monse, and all the organizations that have been supporting this to make it possible. I think that it's been very intense, the whole day talking on ecocide and looking at ecocide from different perspectives. And for me, what is clear is that we are in the right path. We need to come together and to overcome the differences, like in little details, because what we have in our hands is the future of life in the planet. And we cannot lose time to get that. We cannot lose time to get a law to protect the earth, because it is urgent to get it. And it is fantastic. It is great to have these discussions, to see all the points and to listen to different perspectives from different scholars. But yeah, really, I think that we must go for it, and we have to do it now. And so, yeah, we are very, from Stop Ecocide, we really welcome any initiative to talk about ecocide at the universities and in all the different arenas. I mean, wherever, in any place that we are requested, or also we also organize things, because we need the whole sectors of societies. We need the jurists, we need the lawyers, we need the academics, the farmers, the scientists, the students. We need everybody, because this is a law to protect our common house, that is our common home, that is our planet. So we are in the right path, and I am sure that very soon we are going to see the result of all this coming together.
I just want to say thank you very much for all of you. Thank you very much to Montserrat Abad. Thank you, Thomas, for everything, for your efforts that you put in this. And yes, I think that this kind of discussion in the academia are very necessary in this time. So I want to repeat this experience, maybe with different focus, or maybe, I don't know, maybe more time to discussions or something like this. Maybe translation could be, but it costs some money. But whatever, we will do it again, because this kind of discussion are very necessary in that time, in this time. Thank you very much, and see you again in the future, in the next future.